by any stretch, but
all right, good morning, good morning. Thank you so much for coming to the symposium on a Saturday morning. It's a great opportunity to discuss some incredibly important topics. My name is Iria Giuffrida. I am a professor of the practice of law here at William & Mary, and I want to thank the Business Law Review for inviting me to moderate this panel. And I want to thank our speakers for coming all the way to Williamsburg to help us think through some of the issues that have already been kind of laid out by Director Greenwald. What I'd like to do is start with an introduction on all of our speakers. I think that the idea behind this symposium is to make it a little bit more dynamic rather than having speakers sort of present their work, which of course will be very interesting, is to give an opportunity for Q&A to actually dominate the discourse. So what I'd like to do is to kick us off with a couple of general questions once I've presented the speakers, and then we'll carry on with the Q&A. I really would like students, because I know there's a group of you who are terribly interested in this space. This is a great opportunity to speak with experts. So feel free to raise your hand. The idea here is to engage in interesting dialogue. And I do know that at least 5 or 6 of you know an awful lot more than I do. So you should be asking the questions. So let me just introduce our panelists today. Michael Bombace, good morning, is the General Counsel at Jet Protocol, a borrowing and lending protocol on the Solana blockchain. He also teaches at Washington and Lee University School of Law, where he focuses on the laws around blockchain development, specifically decentralized finance. He has worked at Booz Allen, advising government clients of cryptocurrencies, payments, and cybersecurity, and at Citigroup, Ripple, Wire, amongst others. Joshua Fairfield, good morning, is the William Donald Bain Family Professor of Law at Washington and Lee University School of Law. He's an internationally recognized law and technology scholar specializing in digital property, electronic contracts, big data privacy, amongst others. He writes, presents, and advises extensively on the intersection of new technologies and regulation, and the importance of keeping a human in the loop when it comes to the regulation and development of new technologies, especially blockchain. Jerry Martin is a professor of law at the Florida International University College of Law in Miami. He has wide experience in financial services and has written numerous books, treatises, and articles on regulation, securities, and commodities markets. J.W. Verret, good morning, associate professor at the George Mason University, Antonin Scalia Law School, and visiting professor at Stanford Law School. He's a faculty liaison to the American College of Business Court Judges, an independent chairman on the board of directors of Egan-Jones Ratings, and has served, as you mentioned this morning, on the Investor Advisor Committee of the SEC, where he advised the SEC chairman on legal and policy reform. He's testified before Congress and made multiple media appearances. Can we just welcome our speaker? So I'm starting with the general question for the panel. We've heard Director Greenwald talking about the regulatory framework as being able to cope with these new technologies. And so my modest question is, does it matter? How do we legally conceptualize cryptocurrencies? And that will have an impact on how we think, if at all, to adapt or change the regulation that we have. Joshua, I know that this is a question that we sort of discussed. So would you mind opening up the discussion?
Well, briefly then, one thing is that you'd like to help people have the courage to be wrong and clear enough to be wrong. And so I want to clarify the parameters here around this idea that law can't keep up with technology. On the one side, you'll notice that technologists say two things. It's too early to regulate, and it's too late to regulate. It's never the right time to regulate. Conversely, there's this idea that, and as a part of that is the idea that law can't keep up with technology, that the statutes are too old. A Reddit comment I read a couple of weeks back said this: cryptocurrency is doing a speed run of the need for financial regulation in the 20th century. That speed run's doing two things, though. It's not just speeding technology faster than law, it's also speed running through law that's in some ways already there. I'll give you an example. Do you get to inherit your parents' cryptocurrency? Answer, yes. It's personal property. Have courts said that before? No. Is it hard for them to determine? No. If you steal somebody's NFT, do you have to give it back? Yep. Is that the law anywhere in the country? No. Will the law of replevin force you to give stolen NFT art back? Yep. The law is already there. That's what Director Gerwell was saying. Now I'm going to help him be wrong too. The difficulty with the approach, and I thought it was typified by the superb question about decentralization, which is undefinable, right? It's like you have to do calculus and infinitesimals. At what point, how many angels can dance at the head of that needle, right? Is that you have to have flexibility for old rules to capture new cases. That's what the Howey test is. But at the same time, there's no question that the ambit of tests like the Howey case gather in all kinds of behavior, including your investment in our work here at this table this morning, that the SEC was never intended to cover. And some that are very on the edge, and yet we decide as a society are in the right place. Kickstarter was founded, got going in 2009. They were on the wrong side of the Howey test. That's why the Jobs Act was needed in 2012 and why the SEC promoted Reg CF in 2016. Regulation crowdfunding is now the law. Kickstarter was in the gray zone that many of the businesses that we're talking about now, right, are now. They were then. And just so to say Howey is clear, it does have the reach to gather in new cases as they come up. Law can keep up with technology. Whether it should is a different question entirely. And that we do need a process of dialogue, of experiment, and of humility when we iterate these cases, when we find the principles that begin to matter in this specific area to deal with the specific problems. So those are the principles. I just wanted to clarify why I think everybody's wrong here, and I'll hand it off. I'll hand it off to somebody else.
Mike, I saw you sort of nodding and then shaking your head and nodding again.
Well, I don't know. I don't want to say I'm easy, but I'm easy in this regard. Professor Fairfield was actually a professor of mine over a decade ago. And like we very much think alike on this. Kind of a broader. I think it's important to be very technical and very specific. Like, what is Howey? What is SEC's jurisdiction? Why were they created? You know, they're there to reduce information asymmetries and protect public markets and allow private capital formation. And there's a whole mission statement. And I think all that matters. There's a conversation that comes up a lot with startups and in Silicon Valley, and I think maybe more broadly with academics. And it's much broader. And it's, did we get all the benefits from the internet in the first place? And I think the answer is largely no. There's been a lot of benefits. And it's a lot of what has grown out of code and then code 2.0 and the concerns around the internet being the perfect tool of control and trying to maximize certain principles, whether it's freedom or financial privacy and all the rest. And there's this moment in time with, can law keep up? Is it too early? Is it too late? And maybe an even better question is, how do we get it right this time? And then what does that mean and what does that look like? And I don't know. I mean, that's kind of what we're trying to do at JET in a way. I mean, we're focused on obviously product development, decentralized finance, but like, how do we get this right with this policy conversation? What should be regulated or not? So maybe I'm trying to reframe and put the goalpost in a slightly different spot and say, is this nothing more than just the same old thing? Like, we're talking about how humans relate with one another. And if that's the case, and to what Girl said earlier, that it's behavior driven and it's the same behaviors, like this isn't complicated, maybe we're done, and maybe Howey does apply and this doesn't be overly complicated, or is there something special here to the decentralization conversation and point? And I think there is, and we should focus on that to say, do we want to foster that and allow that to grow? And I don't know if that means that there has to be a light touch regulatory approach like CDA 230. It's different. That was information sharing, and this is, at least for now, finance and one particular use case for blockchain. But I guess the concern is that I think we're looking, those that are very pro blockchain view it very differently than regulators. And I don't think either side is necessarily wrong or right, but I don't think we're not arguing or having the same conversation even half the time, it feels like. So,
I enjoyed Director for all speech. I'm glad he came to speak, particularly to some follow-up panels that are likely to disagree with him. I think he crafted a very useful straw man in his speech, and he proceeded to beat it down. But that's what I think it was. And I think it's consistent with the kind of talking points we've seen from the chairman of the SEC. And it's important to point that out to a group of students, particularly some who want to go work at the SEC. And I think you should. It's very important. Throughout the SEC's history, they have adapted to new technology. That's part of the reason why the securities laws have been robust to the development of new technology. They created Reg AB to deal with asset-backed securities that didn't have boards of directors. They adapted to prospectus delivery over the internet. Took them a while, but eventually they adapted to it. They adapted to sharing of company information on social media. They adapted Reg FD to it. So they know how to adapt. They adapted to master limited partnerships and some unique things about those being publicly traded. They know how to adapt. But what we get instead now from the commission is there's been a ton of information going into the commission saying, hey, we're crypto lawyers. We want to adapt regulations in the same way that has been done many times in the past. Here are some ideas flooding into the SEC. And the response from the chairman has been, just come in and talk to us. Or there's a form Reg S, just fill it out, right? Which is kind of an obsequious tone that any of you have taken securities regulation and know a little about crypto, you get it, you appreciate it. Those talking points work in the political sphere and with his political backer who helped him obtain the position of chairman. But for those of us who know something about how securities regulation actually work, we know that those talking points are incredibly misleading. And it's frustrating to the community of crypto lawyers who want to adapt, many of whom are former SEC alumni working in crypto. They're at Coinbase, they're at Kraken, and they're trying to adapt. Notice how the Kraken settlement is a $30 million disgorgement, $30 million. Usually numbers that size involve cases where there's some fraud. No fraud whatsoever in the Kraken settlement. Usually, if there's a non-registration settlement, part of the settlement will be register. But guess what? Kraken's not allowed to register their staking product. Come in and talk to us, but how can I register? You can't really register. Or sometimes they'll give you my favorite response. We don't give legal advice. There's no path to register, and we got you if you don't register. That's the approach the SEC has taken right now. I served on Gensler's advisory committee. I tried to advise him to do something different. He didn't listen. At the end of the day, though, I do have hope. The panels today on the major questions doctrine show, I think, a path to victory in the Ripple case, in the Wahi case, and eventually in the Coinbase case, when it comes down, and I certainly will come down. They're not going to drop it. So that's the path to victory. I hope we get a chance to talk about that. But I think that sets the stage for where we are. And that's why I take a very different view from Director Burnwell on where we are. I wish they went after the crypto frauds. There are a lot of them. But this gotcha game of you can't register, we got you if you come in and talk to us like they did the library, does a disservice to the men and women at the SEC who care about the agency and the agency's focus on fraud and compliance. That's my piece on that.
Jerry, you have a piece that is coming out, I think, on the Business Law Review, thinking about the rule-making powers of the SEC. So how
Yes.
do you frame that?
I've gone to the defense of Kim Kardashian in the charges brought against her by the SEC, claiming that she violated the anti-touting provisions of the 33 Act by not disclosing the amount of her compensation. In her Instagram message, she disclosed that she was, it was an advertisement, she simply didn't disclose the amount. I think that's ridiculous. Everybody on TV touting something is getting paid and not disclosing their fees. William Devane, I think the actor, he's on TV constantly touting gold and never, to my knowledge, ever disclosed his compensation. And gold, well, if you claim that's a sound investment, then you're into crypto, okay? It's just not there. And I think what's the Howey test, I mean, anything can meet the Howey test, as already suggested. You may be in violation as you sit here. For example, I want to rob a bank. I need a gun. I go to somebody and says, if you'll give me your gun, I'll split the bank receipts. Okay, well, we've got a payment, a gun, a common enterprise, dependent on the efforts of others. And if the person wants to be the wheel person, then we need to have substantially due to the efforts of others. I mean, that's the ridiculous side, but then you keep moving down the spectrum. What about somebody who builds a house with a contractor? Is that a security? And crypto, well, sure, you can say that it has all those elements, but sometimes it kind of doesn't. because when you get more decentralized, then you've got an issue of, well, they're participants. Are they partners in the enterprise, which would take them outside highway? Now, the SEC is being accused of regulation by enforcement. That's not the first time. I started my career at the SEC in the General Counsel's office, and they were very aggressive at the time and were accused of being regulation by enforcement. Roberta Kamel, a former commissioner, my law partner, wrote a book about it, and it's touched off a debate for decades over deregulation. Can we stop the agency? And that debate, I think, is renewed now in a little bit different format under the major questions doctrine. But I think that's going to be playing out over the next several months. The one thing that I think we're overlooking, and I'll talk about it later this afternoon, if you haven't had enough of me already. So is that, well, what is this statute? How can we create a statute that is actually effective? And what we're seeing now, or at least the legislation I've seen, is tending to saying, oh, well, if it's security, the SEC's got it, and if it's a commodity, the CFTC's got it. Well, crypto's dead if that happens, okay? There's no way they can survive kowtowing to both agencies. It's just not going to happen. I think we need to take a policy look at what is needed for the regulation or statutes that we adopt. And I've got some thoughts on that, but I'll save it for later.
Are there questions from the student? Please go ahead.
For Professor Fairfield, I do have a question, and maybe this might be unanswerable, but with the advancement of AI and ChatGPT, how do you see that affecting accountability in this context? Because as the panel is, it's old laws applying to new context, and definitely I feel like that's a way that securities and broker dealers are going, is more to an AI route. How do you think that old laws would apply in that context?
Wow. Superb question. The challenge for me is to give a clean answer.
You don't have to. I don't know what you're saying.
We advance law by using our superpower as a species to develop new narratives through language. That's what we're doing right now. The problem with AI, like ChatGPT, is that it's a neural net. It learns from colossal numbers of exemplars of our speech, but it does not generate new meaning. It can't attach meaning to anything. If you feed it back into itself, it's like the world serpent, it eats its own tail. The problem is that with everything from political astroturfing to crypto offerings, AI-generated speech isn't human. It doesn't mean anything. Humans read it, we take it as someone else talking, and so it changes how we talk to each other. There's a real risk in this space, especially on questions like the disclosure question that was asked earlier. There's a real risk that we become unable to trust that we're even talking to a human. Edgar Dijkstra, the famous physicist, among other things, said, among other comments on this, the question of whether or not a machine can think is no more interesting than whether or not a submarine can swim. AI is competent to our tasks, but it does not have our interests in mind. It does not have our welfare in mind. So things like speech or around disclosures, which do matter to investors, or crypto offerings that are targeted the way we've seen political offerings targeted to people who are uniquely vulnerable to that message, I think will strongly exacerbate the end of the spectrum that I don't think anybody at this table wants to see happen. It's a method for targeting and dropping people the messages that they will be most receptive to at the moment that they're weakest to it.
But aren't credibility mechanisms going to apply to that tool just like anything else? I mean, aren't AI-based diligence tools going to evolve that we're going to figure out we like using, but doesn't matter whether it's a human generating it or not? Isn't AI the answer to problems with AI for the most part?
So when I presume you're referencing GANs, what are called generative adversarial networks. The difficulty is that anytime to train an AI, what you want to do is set an AI to catch the AI to see if it's doing a decent job. It's a zero-sum game. You set up a zero-sum game where the one AI is talking to the other. So I make a false disclosure. Then can you catch me making a false disclosure? Then I make a better false disclosure. Then and you catch me making a better false disclosure, that arms race rapidly passes humans' ability to determine what's going on here. We failed the Turing test on Twitter a long time ago. And so my general view is that what the relevant metric here is not whether you can set an AI to catch an AI. It's whether or not, because let's try this. The same mechanism is going on with viruses, with computer viruses. You have antivirus programs and viruses, and the one tries to catch the other, and it's an arms race. But there will always be viruses that get past the antivirus. By definition, they're the ones that exist. And so I think disclosures that do pass credibility screening are exactly the ones that will reach targeted.
I think I'm behind. I'm going to take advantage of this. The reason why God also this arms race is because then there's behavior. That's our behavior, right? So we want the AI to be better. We want
But the same arms race in traditional human financial fraud that's been going on for 100 years. Right?
It's not the machine, it's us.
So given that we don't know the outer limit of how should enforcement reflect this novel context?
I'm a huge fan of sandboxes. I think a lot of people around the planet have said this. Look, we understand you're in the Kickstarter space. You're inside our jurisdiction. You might be over lines we decide to draw later. What we're going to do is if you tell us exactly what you're doing, we will provide you with some significant, verifiable protection against us dropping the hammer on you later on. And we will give you an opportunity to talk to us before we do it. I think sandboxes are a way better way of doing this than retroactively saying you were inside the bad Howie. Because there's bad Howie, and what nobody wants to admit is there's good Howie. There's Kickstarter Howie. We're all in Howie. The question is, are we the goose laying the golden egg or not? And can we demonstrate it and get away with it? Look, this is how tech businesses start up all the time. Everybody starts these things up on the wrong side of the law. The last time it happened, years ago, the huge case was Redigi. Redigi said, I'm going to let you resell your used MP3s. This other district in New York said, no, you're not. But that was after they started the business, right? Spotify began on way the wrong side of the law. Grooveshark, remember all of these? They all went away, and then Spotify survived. I think we've got to recognize that that's the reality of how these businesses start. They start in the gray area because that's where nobody's built a business yet. And I think a sandbox is a legitimate way to talk about the fact that you might get the line drawn behind you. We're going to give you a chance to get in compliance before we drop the hammer.
Your sandbox supporter.
Am I a sandbox
Yeah.
supporter? I'm not sure I even understand, but if we're saying that you come to the agency and they draw the lines in the sandbox?
No, I'm saying they admit that you're in a gray area and that you're going to, that by disclosing to them what you're doing, they protect you against retroactive enforcement.
Well, so I'm a libertarian, and that sounds like the government is telling and deciding what's going to, you should and shouldn't do, and I'm by nature against that.
And I'll take a profoundly anti-libertarian stance
Yeah.
and say, there's a lot of fraud here. That's not what many people of good faith and good conscience are doing. But nobody can look at this space in good faith and good conscience right now and say we don't need responsible regulation. We do. We just need it to be done in a way that's responsible.
I think most crypto lawyers are calling for that, and they're getting ignored. And that's why I think in the near term, the ideas have already been introduced. They've been filed with the commission, just being ignored. In the near term, it's a purely defensive move. I think we're in a purely, as an entire industry, purely playing defense on the aggregation of how we, not just in the crypto space, it's a test that has grown and grown over time, well beyond the initial meaning of the 1946 case. And the reason why judges have allowed it is because it's usually going after frauds. This is the first time Howie's been abused to go after totally, well-meaning actors that are just don't have a path to registration in pure non-registration cases where registration is not allowed as a part of settlement. That's what's new. The judges see that. We already saw it in the Voyager case. The judge said, "What are you talking to me about? Get out of here!" Right? Director Gurwal didn't talk about the ruling in that case. He doesn't want to talk about it. I think that's the tide turning. I think we can convince the circuit. We can definitely convince Justice Gorsuch, and that's I think what the next panel is about, to take a similar view to the federal judge of the Voyager case.
let me jump in here. It's also recorded, so I want to be cautious about what I say because, we're a DeFi borrowing and lending protocol, and we're solidly. I was the first hire that the founders had, and it was out of an abundance of caution. And both founders had been around and in Ethereum during the ICO craze, and they saw how all of that had evolved, and SEC enforcement and settlement agreements and all the rest. And when we began development, it's front and center. We want to be thoughtful and ethical. We want to do right by consumers. And so we're going to, of our own accord, disclose things in a way that other protocols might not. And we'll kind of over-rotate on that because it's all, you want to be transparent. You want something to stand the test of time. You want something to be around for 10 years. You want to build something that's really thoughtful and exciting and pushes the bounds of finance. But maybe we're at the far end of the continuum of good actors, and we're special or something. I don't know. But as we go to build and evolve, this changes the very thing that you can build. And so that, to my earlier point of, here's a moment, if it really comes down to we're humans, what do we collectively want? Don't worry about AI. It's just a tool. Blockchain is just a tool to change how we relate with one another, what ideas we share, how you consume media, and hopefully getting it right this time where you can actually own your reality and you're not stuck under a licensing regime. And Spotify's lovely. You get all sorts of music that maybe you wouldn't otherwise, and you're not rolling around with CD cases and everything. But it seems like we've slipped, and that individual rights and liberties have slipped, and that you don't get to own your world anymore, that you've lost that to these giant tech companies, and you live in these vast silos online, and then there's all sorts of problems from that. So it's like, can we start in the first instance to say, what kind of world do we want? Can we begin anew this time and fight for that? And that the particulars of something seemingly that no one had ever heard of before, that was never in contention with securities regulation, the Howey test is now front and center because it is the very thing. If it's not a security, we're done here. Like, you're something else. It's a fight over what is a security and should this be reframed and rethought of? And is decentralization the thing? Like, is something actually decentralized? And that's something that we agonize over in the creation of governance and voting, and should there be a token, and does it come with governance rights? And do you want people to, more like a credit union, like you get to own and vote and shape the very thing that you're using. And you're not stuck with a different model where Wall Street owns everything and kind of shapes it. If you own Google stock or you own JP Morgan Chase stock, like, are you really going to show up and vote and change the conversation? Like, probably not. So it gives me gray hairs to worry about these things. So, it's a real problem.
So, Jared, do you have Marcel?
Well, just going off of what you just said about governance, I like to believe the same thing, that it's fundamentally different from the stock market and voting on traditional securities. But I do notice that, I participate in crypto. I have for years. I vote on a regular occasion for the blockchains that I participate in. But recently, there's been a lot of blockchains that are introducing things like delegated representatives, where you can either delegate your voting power to a particular individual through the blockchain, or you could delegate your assets to a stake pool operator or a validator, and they're essentially voting on your behalf. And increasingly, as these blockchains are competing on economies of scale, you see sort of a concentration of either the validators or, influential individuals, whether they're developers or whatever, that have, an excessive influence on other people's votes. And a lot of that at its root is because, it's complicated stuff that you have to vote on, and it takes a lot of time to actually look at the proposals. Some of them are more simple. Some of them are purely, populist attempts at grabbing money or funding. And, as you decentralize more, you have to rely on decentralized funding as well to develop the ecosystem, right? And so the source of that funding has an increased effect on the network. And if any of you have anything to say about that, how to resist those centralizing pressures and how it's fundamentally different from voting on Google, for example.
I'll offer a short response because I'm actually deathly curious what the three of you think about this. Maybe not the world's greatest answer, certainly not a legal answer, but humans prefer efficiency and nature doesn't. Nature prefers resiliency. And I don't think in the long run, efficiency is always the thing to look to. And humans are weird and difficult on a good day. And if you're trying to police against bad actors and bad behavior, it usually is better if there's a variety of options. Yeah, choice paralysis, you don't need 100 bars of candy. You know, maybe you just need 6 and you're fine. But with financial services and things that merge different concepts, so in one moment you have something that represents a voting interest, you know, an investment of yours, an NFT, art, like you're merging concepts into one medium, and the medium has become the thing. Like that's, a lot of this is, do we want to incentivize blockchain? Do we want to incentivize a decentralized reality? Or are we going to not fight tooth and nail for this? And we're going to have the issue of convergent evolution, or if you put all the same requirements on a system, it's going to look the same over time. And then all you've done is you've taken interesting tech, you've stuffed it in a tech stack, you put it at the bottom, and everybody doesn't really get the benefit of it. Because beat up on Jamie Dimon, JP Morgan, but maybe you're getting some of the benefits of DeFi, but the bank is the intermediary, they're getting those benefits, and maybe they pass it on to you in slightly lower fees. But if it just ends up as a way to save, record, and share data amongst banks, I feel like we've completely lost out on this. So ultimately, it's, I don't know, fight tooth and nail. I don't know, that's not a good answer, but.
It's a great irony that progressive firebrands like Senator Warren or her protege, Chairman Gensler, he was her selection with the Biden negotiations with the Biden team. They are fundamentally protecting traditional financial intermediaries and an intermediary-based system. They made a name as the anti-Goldman Sachs, anti-big bank in the 2010s, and now they're fundamentally protecting that intermediary-based system. Look, if they gave some guidance tomorrow about how the treatment of staking, which is effectively just like a deposit with a landlord where you earn interest, basically a security deposit where you earn some interest for the time your money's there, or how are miners treated as underwriters? Gensler's not going to give us any guidance that they're not, and he could try to do that. I hope he would lose in court, but there's risk that miners get treated as underwriters, which turns any network up on its head. So how does a network survive without either of those two ways of obtaining consensus? And I want to be clear on this. We heard a lot about investor harm from Director Grewal. Chairman Gensler and his intransigence and his unwillingness to consider more moderate approaches from the UK, from the EU, from Canada, has caused more investor harm and asset owner harm than the frauds themselves in the United States over the last year. And I think this is a point that was made by former Commissioner Grunfest with the XRP case. That's deeply disappointing. There's an alternate path to go. Regulation X is one proposal that was filed with the SEC that has model disclosures about DeFi protocols. There are a lot of different ways to go, but I think there's a lot of investor harm in Coinbase investors, a lot of asset owner harm in XRP holders and AMP holders in the Wahi case that are doing the opposite of what Director Grewal described as his goal in office, and that's disappointing.
Let me take it broader. One thing is this is about regulation. We've been focused on SEC for obvious reasons, but there are a million ways of coming at this. We use these assets in many different ways, and each way that we use it gets a different regulatory regime. But there's a broader principle that cuts across all of this, which is the claim that cryptocurrency or crypto networks don't need regulation because they're decentralized cuts against the basic fact that they all re-centralize. Bitcoin, clearly the most decentralized, so decentralized that they can't even find the person for good reason, because they've already gotten the knock. And yet, the people who write the code are one source of centralization, and the mining consortia are another source of centralization. The delegation that you're talking about, these broad delegations and stakes and ICX and similar, immediately re-centralizes in these massive voting consortia. If decentralization is the reason we don't need trust in these networks, to be provided by social narrative, that is not adequate. It is not adequate protection. We cannot replace the need for socially guaranteed trust by technologically guaranteed trust. The promise of decentralized networks, which is that they are so-called trustless, just ain't so. Take a look at the original DAO. It was hacked. The money was stripped out of the smart contracts. They did not go to a technical solution. They went to the community. They said, fork it, undo it, fix it. Look at ICX, same thing happened. Bug got exploited. They went to the community and said, fork it, stop the bad actor. Over and over again, these are social solutions to technological problems. I don't think there's a way to do it other than to recognize these things have a tendency to re-centralize. The re-centralization prevents a risk, establishes and creates an identifiable risk that they need to either keep it decentralized or have someone look at the central actors who are now capable of acting in bad faith.
So it's almost like for regulation to sort of follow that re-centralization.
That's why I thought that's why I thought the decentralization question was so damn good, because it wasn't just when does it stop being a security and start being utility. It's like, when does it become a security again, right? Like it's Schrodinger's security. It never stops, depending on the degree of centralization and decentralization. And I think that the community does not keep dead center crypto networks re-centralize by laws of freaking nature. They re-centralize, and pretending they don't, and therefore we don't need to regulate them is a huge mistake.
That's a libertarian approach here.
Okay, so what's nice about the debate is that it tells me there's a debate. So this is a political question that needs to be resolved, not by the SEC through an investigative report that was unchallenged in court and through staff guidance for which public comment was not sought, to regulate this very controversial area of our economy. And I understand that there's fraud. We were told that it was completely trustful, that unbreachable and totally safe, and obviously it's not. But merely by labeling it as fraud doesn't make it a security. So, and the same thing, is it a commodity? Is it a spot market commodity? And there's fraud. So forget all this law stuff that you learned in law school. It's fraud, so we got to stop it, and we'll just call it whatever we want to. So that's my response.
Clarity is a beautiful thing, and startups do want that. There are some entities that like to operate in the gray and they want to keep it that way, but for broader use and consumers and investors and whether institutions are going to use crypto and DeFi to a greater extent, clarity would be great. And I'll actually promote FinCEN here, Financial Crimes Enforcement Network. Is anyone familiar with FinCEN? Tiny bit, quarter bit. So they're a component of the Treasury Department, and they were born out of a variety of things, but a lot of it was around bank secrecy and anti-money laundering and trying to come up with a better way to tackle financial intelligence to support law enforcement investigations, among other things. And when FinCEN came out with their guidance in March of 2013, it gave a lot of clarity very quickly to say, yes, we're reasoning by analogy and old, new tech, but old buckets. And if it's money transmission, then we have a whole framework for that. And this is very easy. And seemingly for most crypto, that works really well. Like you can look at Coinbase and say, yes, arguably and very clearly that's money transmission. I'm giving them something of value to then send on to a third account later in time or immediately. And that fits really well. So with that guidance, everybody came into compliance relatively quickly, and there wasn't too much pushback. But a lot of the conversation has been SEC hasn't given nearly enough guidance. And if you're using enforcement as the framework to start to create what is law or how people should behave, I guess you can do that. Like I had interns take the Wahi case and they look at each token that was identified to come up with do this, don't do that. And this is how to look at Howie a little bit more clearly. I think there's still a problem because the medium's the thing and decentralization's still present and there's still so much, wiggle room there. So I don't know. SEC has known about crypto for quite some time. I actually briefed SEC in 2014 when I was at Booz Allen, and it's like, I don't know, you could have issued more guidance, but.
response here, yes.
So again, FinCEN came out and said virtual currency is not a real money. But we don't care about that. We're going to make you a money transmitter anyway. So Venmo and PayPal and all those people, they transmit money. But since you're a thing, anything can be transmitted therefore, we're going to treat you as a currency. Now, again, it may be a good idea. Maybe that's what we need to do. But it was made up out of whole cloth that they put this particular asset into the quote money category when the IRS, all of the major accounting firms says, no, it's not a real currency, it's something else.
I mean, it's called cryptocurrency. Well, they called it a money substitute because it was, and I know this is shocking, a money substitute.
So that cuts against the Howey test, though, right?
Sure, but look, that's the thing. We need a humble, iterative, experimental approach to this stuff that keeps this tied to how humans are using it. If humans aren't using it as securities, it should not be governed by Howey. If they're using it as a money substitute, then they need to be subject to that. If they're using it as a commodity, it should be under CFTC. We have the law here already. That part of Director Grewal's speech, I think, was dead on. The problem is we've got a bit too ambiguous of law, given the wide ambit of Howey in one particular place.
Look, I know crypto lawyers at Kraken or at DeFi protocols like Uniswap, Aave, that have been resilient through the crisis, that have done well and better than the traditional financial system and economic crisis of the last couple of years. Look at the bad actors, the number 30 DeFi protocol that's a scam, and they say, I wish the SEC went after that rather than the bullshit Kraken settlement. That's just a way to it's like there's crime in the neighborhood and the cops just pull over the soccer mom and they're like, $2,000 fine for you. Kraken was one of the best actors in this space from the beginning. They helped resolve Mt. Gox in 2014. To pull them over and say $30 million fine, quit your staking, and there's no registration path for you is absurd and undermines the agency. So yeah, I totally agree with you on that.
So the idea of regulation by enforcement has come up several times. And to me, it feels a little bit like common law development, and what Professor Fairfield just described sounded a lot like common law development. So I'm curious if we say like regulation by enforcement is bad and not what the regulators are supposed to be doing. Can you describe like the iterative process that law is supposed to develop to engage in regulation? Or alternatively, like if the federal securities laws shouldn't cover this, what are the other like regulatory bodies or spaces or actors or institutions, like at the state level potentially, that might provide like a more comfortable foundation for crypto regulation?
I'll give you a short answer. So Chairman Gensler has said in a speech, maybe we should look to Reg AB, the ABS that I mentioned, as a way to regulate crypto. Okay, great, do it. Do it. It's been a year and a half, he hasn't done it. He's mentioned it in his speech as a way for people to come in and comply. You may be someone outside of, you don't have a company, you don't have a board, but somebody could do some disclosures that could be useful, formulate on that. Do it. He just has to do what he said he might do.
So let's assume that most of the people here, including myself, don't know what that means.
So asset-backed securities.
Let's just assume, and I'm going to say that that's like not an unfair assumption. Can you walk through like the regulatory framework that you're suggesting and like what Chairman Gensler is describing? Because I think we're hearing a very top level discussion, and for us to internalize it, I think we need it like a little bit more broken in, because most of us are 2Ls who maybe have like a semester of securities.
Yeah, so asset-backed securities come along, people start packaging up loans, put them into different kind of weird vehicles, and then sell off equity interest in the packaged loans. They don't have boards, they don't have CEOs, they don't have proxy fights, they don't have a lot of stuff that goes along with a normal publicly traded company. So they go to the SEC, and the SEC said, all right, we're going to create a new category. This is not equity, this is not debt. We're going to call it asset-backed securities. We're going to have a whole regime tailored to what you really need to know about this thing, but we're not going to apply the pieces of securities laws that don't fit, like proxy fights or like boards of directors with an audit committee and stuff like that. So we're going to create some exemptive relief for a lot of that stuff, and then go. There you go. There's a new reg to comply with. So he said he might use that as a way to regulate crypto, as a kind of a basis to tailor. Great. It's been a year and a half. All I see is a bunch of enforcement cases and a bunch of talking points. Come in and talk to us and that stuff. Deliver on that.
I mean, I do advocate for the common law method for regulation of tech cases. I think it's particularly telling that civil jurisdictions like the European Union at the EU level use a common law method for their tech regulation cases. There's a reason why cases like Gonzalez, the right to be forgotten, and other key EU, the Schrems 1 and 2, the privacy cases, right? See, before the CJEU, this is a common law process. Why? Because when you bring a new case, a technology case in front of the court, the whole point is nobody's asked it before. And so there isn't, if you go look at the statute in the standard civil system saying, well, what chapter and verse is this under? You don't necessarily know yet. I think there's parallels to this within, and I know this won't win me any friends here, but there's parallels to how this works in US regulatory frameworks. The FTC, for example, is our only privacy watchdog on the European model, and does it because notice and comment is a restrictive process that is designed for them not to be able to pass regulations. They do exactly this. They create common law through their settlement agreements. And I think that maybe the SEC thinks that there's a similar process here. Now, that said, I agree 100%. If we have there's no question that if we have Reg crowdfunding, we have Reg CF for crowdfunding, we have Reg AB, we're gonna have Reg crypto. Like there's not a question that that will happen. And in 5 years, I hope, 10 years, absolutely, I'll take any bet of any amount of crypto you care to name, that will be in place. And I think the sooner, the better. And I think it needs to be done in good faith. There's a lot of damage happening in the industry right now.
For now, just survive. Just don't settle. Don't come in and talk to them. I would never tell a client to go in and talk to them just cold. I think that would be malpractice right now. Survive, defend, use the major questions doctrine. Ripple is doing a hell of a service for the rest of the industry. No matter what you think about XRP, you're a fan or not, hell of a service for the rest of the industry. For now, survive, but eventually we'll have a real adult conversation about tailored regs.
Just a second, Professor.
So your question, I think, is why we're here today. Does the agency create common law? Or is, in particular, an area of major questions, must there be clear authority? So common law, we look at things, we make up a decision, we use the facts and circumstances, but in a major question, I think, we don't know really what it means just yet, that's the issue. Can an agency create a common law system of jurisprudence?
Mike, I felt like you had a...
I'm like coming at this from the student perspective a little bit. There's all these different avenues to, if there's behavior and conduct that doesn't fall in a bucket, do you create a new bucket or do you expand the bucket? And it seems like SEC is saying, at least with securities and investment contracts and tokens, it's analogous enough that we just expand the bucket and we're done. Like it's easy. Don't forget, people don't like to do hard things. I'm not suggesting that SEC is lazy or anything like that, but these are hard things. It takes time and effort. People are leaving SEC to go into private practice and go elsewhere, go to startups. So they have, they're low on resources, they're low on talent, and they don't want to just let this slip and not be regulated in some fashion. So in their defense, they're like, we'll go the easier route, and we'll just throw it here and call it done, as opposed to the let's be slow and thoughtful and come up with another framework, and we can pull tools from other buckets and say, disclaimers are good, but you're not built the same way, so we're not going to regulate you as if you were a duck, because you're not technically a duck. Maybe you're a platypus. Yes, there's a bill, but whatever. So the AB approach would be you're pulling tools from other disclosure regimes and other products that are regulated to come up with something close. But we're focusing on SEC here a lot because it's front and center. And as a DeFi protocol, there's a couple things at play here. There's a token, because that's how you're raising money. You're selling it to the public or accredited investors, or you're doing an offshore sale of a security, Reg S. So you're looking at Reg D, Reg S. And that's going to be your governance token typically, because you want to be decentralized and you want the community of users to participate. At the same time, you've built something, a protocol, and it offers a product or service of some sort. So you have to analyze that too. And is this a security? Is this a derivative? Like, what are we doing here? Not only is SEC a concern in CFTC, but it's pretty much everything. And I'm not trying to argue I don't want to be regulated. I think regulation is a good thing. I think law has to keep up. But it's also zooming out and saying, how are we going to treat DAOs? Are these a legal entity unto themselves? Do they need a legal wrapper? Is the medium the thing in decentralization? Do we want to look at this as a new way of organization and coordination for people? Or is there enough already on the books because of the abstract relationships where you have unincorporated association, an LLC, a C corp? Does that cover all the basics? Maybe it does. I have my own personal opinions, but
Against all this regulatory framework, it doesn't sound like it's working very well. Now we've got MICA, the marketing in crypto assets that has been cooking at European level. Do the panelists think that it's likely to have an effect a little bit like the GDPR had on privacy, sort of creating a standard that other countries, willy-nilly are going to have to enforce, or because of the decentralized nature of what we're talking about, that's going to end up being a European way of regulating, but it's not going to have an impact sort of outside of the EU cyberspace, whatever you want to call it.
It's kind of ironic. I'll call it maybe an irony again about the ironic Chairman Gensler. In the 2010s, he argued vociferously that CFTC needed to harmonize swaps and commodities regulation with the EU, right? And now he's been asked, in MICA, in the UK and Canada, there are somewhat different degrees of accommodative regulatory regimes for crypto that don't, I can quibble with some of it, but none of them are looking to kill crypto. So what do you think? And he says, well, we've got our own regime. We've got our own very unique regime. We don't need to harmonize. We don't need to do that. It's inconsistent with his time at the CFTC. It's unfortunate. Eventually, hopefully, though, it will move toward harmony. But there's just no road to that right now. The politics are what's driving this, I think.
Yeah, for the Europeans almost cannot afford having an impact in terms of killing crypto because internally there's a lot of discontent that privacy has slowed down innovation in Europe, right? So this is the thought I would have thought behind the mind of trying to be careful and not to be too heavy-handed. The Europeans have been historically heavy-handed from that perspective. What's your view on the EU impact, if any?
Yeah, I think that the reputation and impact of the GDPR has been broadly sets a global standard because it sets restrictions that are applicable to U.S. companies. And I think that MICA is different because it provides a degree of permission rather than restriction. And so EU permission isn't going to do anything for the U.S. market, whereas EU restriction on the transatlantic data trade does an enormous amount over EU citizens' data in U.S. companies' HR departments, for example. That is, that restriction binds U.S. companies in a way that EU permission isn't going to do. So I don't think MICA's going to have other than there has been a surprising trend over the past 20 years where, if I can quote from The Simpsons, the U.S. generates a lot of technology, but when it comes to regulation, we've tried nothing and we're out of ideas. I think that abdication here is a real risk. I think we ought to have responsible, well thought out, reasoned regulation so that we show that we're a player in the market, or we're going to abdicate the way we did on privacy. And I have taught for nearly 20 years. It is wild to teach my privacy class, and I'm primarily teaching EU law. That's a first for me. I think that's a profoundly different. Experience, and I don't want us to abdicate here.
Person's effect.
So, again, this is policy, okay? And I'm thinking in terms of the major questions doctrine, does it establish clear authority? And I seem to recall some debate on the Supreme Court about how international standards were not supposed to be the standards that we use. So if we're litigating this case, I would argue that these are irrelevant. Important policy issues, beyond a doubt. And they may be the best model. And I agree that we should have regulation that should be leading the world. We're a financial center. But as a lawyer making a legal argument, I don't think that's persuasive. That's just me.
Mike, your thoughts on the...
I don't know.
It sounds a perfectly logical answer.
Something that I'm really curious to see how it evolves, and it'll have a very direct and real impact on product development and the evolution of DeFi protocols. And it sounds a little hokey, but those tend to want to be free and national. Like, you want to launch something, have a UI that anyone can access, and then you're done. Now, there's some consideration for, very serious consideration for sanctioned regimes and trying to adhere to OFAC. Who here knows OFAC? Okay, you should all, okay. Well, Office of Foreign Assets Control, it's in charge of the specially designated nationals list, among other policies or policy programs that they have. But it's basically, we're not going to allow individuals, terrorists, identified banks, regions or countries or regimes to access the US financial system, directly or indirectly. So you want to implement that to try to be a good US citizen, corporate citizen, because a lot of those regimes aren't, it isn't just a US specific thing, though sometimes it is. But when you look at these different regimes that pop up, legal regimes that pop up, the US, the EU, it's not easy, but it's doable for someone like Coinbase, because that is a singular legal entity with a team and a board, and they're executing and they're building products. And even if some of their products are DeFi focused, it's still, you know, the adage, not your keys, not your crypto, like they are offering the product or service. So they can set up legal entities overseas, and they can hire a global PEO and hire people there, and then launch services that service the EU or South Africa or Australia, etc. If you're trying to build something that is permissionless and on a protocol, and for everyone to use an open source and allows other protocols to build on it, and that's a huge shift forward and why it's so exciting in this decentralization argument, that it becomes something truly new and different, because the speed of innovation goes up, the complexity goes up, but at the same time, they're hyper transparent. And in some ways, they're actually simpler and safer because they have to be by design, because of how they exist, and that there isn't a team constantly behind it, modifying it and collecting tons of fees from it. I don't know if that space can continue to exist and evolve if jurisdictions exert their old powers and those barriers are erected in cyberspace, so to speak, and you can't have a product that's transnational, really. Not anymore. So convergent evolution, you're taking these old requirements. So new tech, old law. If you keep stuffing things in old buckets, you're going to keep getting kind of the same result. So this isn't an argument for no regulation and let DeFi fly free and, you know, the world would be a better place. Like, not my argument, far from it. But we need to either have a lighter touch regulatory framework, a harmonization of some sort. And while sometimes they're restrictive, at least with MiCA, and payments and anti-money laundering, those things are closer to being harmonized globally because they must, versus securities, which is more, I don't know, territorial driven.
I'm looking at the time. I just wonder whether I can just ask the speakers to give us a nugget. If there's one thing that you want us to remember from this panel, what would that be? Some of the students are going to go and work in the space, whether it's advising client or from the government perspective. What could be a good wish for them, something to keep at the back of their mind? It's a difficult question. I should have told you in advance.
Who's going to win the Final Four? No, I think what, from my perspective, is that I think what we're seeing here is that there is a debate here, and these are very important questions, and you see different ideas of what we should and shouldn't do, but my pitch is that it should be done in Congress, that this is that important an issue. And they may get it wrong, they have before, but that's our representative, our elected representatives, and right or wrong, good or bad, that I think is a proper mechanism for regulating. And we'll talk more, I think, on the
Next panel.
I think law can keep up, and the best way we've seen is through something akin to the common law process, through the inevitable, no matter what Congress decides, there will always be another question. And so we can't have Congress decide these new questions. That never works. We will always have new questions to bring. And so what we need is a humble, experimental, iterative, repeated process to cycle these cases again and again and again and develop rules organically by analogy the way the common law does.
I would say 95% of projects in crypto are either a scam or they're not going to work. And the other 5 or 10% are going to completely change the world, change the economy, change the financial system, change social communication completely. The SEC's intransigent, obtuse kind of approach right now is limiting the ability of investors to discern one from the other. It can't last. It won't last. For now, the only thing you can do in crypto is defend yourself, is build anonymously to the extent that you are able to do so. And if you get an investigative notice, if you're not able to build anonymously, contact me, an attorney. For now, help is coming. Regime change always happens, and there's no way for the next chairman to be worse on this question. It's not possible. So I think help is going to come eventually in some kind of a new regulatory approach, similar to the UK and the EU and Canada and so many other countries. But for now, it's keep your head down, build anonymously, but I think that this technology, components of this technology, are going to fundamentally change the system of finance, and less importantly, securities regulation as well.
I agree. I don't know that I agree with those percentages that 90% are fly-by-night operations, although maybe. I laugh. I play a clip of Moneyball, the movie. I love it. To class to say when you're changing the system, you're going to get kicked in the teeth and people are going to freak out, and it's a process. It's a process. What I was going to say, I tell this to class and even to Jet and others. If you're thinking about life and these arguments as a transitive chain, A, B, C, D, E, you can't drop a letter and say something magical happens here or wave your hands. You need to be exceedingly disciplined through your analysis of everything. And if there's hand waving, which is what he's getting at with SEC and Gensler, and an incomplete argument, you want to try to understand the ecosystem really well, both the law and then the tech, so that you can go A, B, C, D, E, show your work, and make the argument and say this doesn't apply because of X, or the securities law are a bad application because of Y, and here's the tech, and here's how it actually works, and here's all the constituent pieces and how it works. And then if you overlay Howie, this is where it breaks and why. You can't wave your hands and say, oh, evil, bad, and we're going to lose innovation. It's like, that's a terrible argument. So.
Please join me to thank the speakers. Brief intermezzo before the